Well, friends, colleagues, welcome to what's labelled the third session of this wonderful conference, India and the International Regimes. It gives me great pleasure to be here chairing this session. My name is Simon Evans. I'm a professor in the law school. I work in public law and also Pro-Vice Chancellor International for the university. And we have two very distinguished guests speaking in this session. They've insisted I give them the briefest of introductions to enable our time to be spent on the ideas and discussion. They are Professor Yogesh Tyagi, Professor of International Law at JNU, who will speak on India and human rights, and Ambassador K.C. Singh, who was, during his long and distinguished career with the Foreign Service, ambassador to the UAE and Iran, and held a variety of other posts. He will speak on India and the nuclear regime. Each will speak for 15 to 20 minutes, leaving us a good 20 minutes for questions, comments, and discussion at the end. Therefore, call on Professor Tyagi.
Thank you, Mr. Chairman. I must begin by congratulating the Australian India Institute under the dynamic leadership of Director Amitabh Mattu and his wonderful colleagues, Alice and others, for organizing this very exciting conference. And I must also thank them for granting me the privilege of addressing this wonderful audience on the topic of India and human rights. I have a framework for my presentation. It consists of 5 components. The first is a statement of the objectives that I have for today's engagement with you. And that statement will give you an idea of what I'm going to talk about. My presentation seeks to understand India's aspirations in the field of international law and human rights, to reflect on India's practice of international law with a special reference to human rights treaties, to point out both enthusiasm and reluctance in respect of international law and human rights, to underline that power diplomacy and rule diplomacy are mutually reinforceable, and finally, to plead for India's greater preparedness for both what is called lawfare, not warfare, lawfare and human rights treaty practice. The first question is aspirations. Since there are 2 aspects covered in my presentation, I would like to oversimplify them by dividing into 2 parts: aspirations concerning international law and aspirations concerning human rights. Like any state, India aspires to attain its objectives, national interest, and it wants international law to act as a facilitator, as an enabler. And in this regard, the minimum interest of India, like of any other state, is to preserve territorial integrity, political independence, and sovereignty. In particular, in the current scenario, India expects international legal structures to operate as a shield against international terrorism. That is why it has taken an initiative to get a comprehensive convention against international terrorism adopted by the United Nations. Like other great powers, India does not want international institutions to act as an arbiter in vital national interest matters, and that is why India has attached a very heavy set of reservations to its acceptance of optional jurisdiction of the International Court of Justice. Being an emerging economy, India does not want international legal structures to arrest its rapid economic growth. That's why it does not want the environment agenda to trump the development agenda. Since its aspiration to be considered a great power has historical roots that became public even before the country's independence, India does not want international law to constrain its rightful status in international society. That is why India's advocacy of the principle of sovereign equality seeks to expose the infirmities of two very powerful regimes, one NPT, which is considered unequal, and the CTBT, which is considered unrealistic. India expects international law to facilitate the process of its recognition as a great power, with the prospect of its admission as a permanent member of the United Nations Security Council as soon as possible. India's aspiration to become a permanent member of the Security Council is as old as the Council itself. In fact, the very first speech delivered by the Indian representative at the United Nations General Assembly, when India was not even independent, indicates India's desire to become a member of the Security Council. Now, how these aspirations are articulated? Being a lawyer, I have adopted a legal framework to share with you how these aspirations have found expression under Indian law in particular, and also under various international treaty regimes to which India is a party. The most authoritative expression of India's commitment to international law is found in the Constitution of India, particularly two articles, Article 51 and Article 253. And the importance of emphasizing these two articles is that they were adopted, or they're part of the basis of India's republic as it is in existence right from its independence. Article 51 states, "The state shall endeavor to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealings of organized people, and finally, encourage settlement of international disputes by arbitration." Each one of these words have special meaning in the context of India's international law policy. During the debates of the Constituent Assembly, one of the prominent members, Mr. Iyengar, said that Article 51 is one of the most important articles of the Constitution of India. Article 51 provides the legal basis of not only India's international law policy, but also its foreign policy. In fact, this is the only article in the Constitution that talks about international relations. Then you have Article 253, which states, "Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any other country or countries, or any decision made at any international conference, association, or other body." This article appears to be quite simple today, but when it was incorporated into the Constitution of India, it was a very major decision because India had a very large number of states that were likely to be part of India in due course, and a large number of them were afraid of having this provision in the Constitution of India. But still, to maintain the sanctity of commitments made by India at the international level, in anticipation, the framers of the Constitution incorporated this provision to give respect to treaties by way of enacting domestic law. There was some concern, but finally that provision was accepted. Some opposed it. In fact, some opposed it by saying that Union cannot have a power to make treaties that transgress the jurisdiction of states, and if it is allowed to do it, that will be a damage to federal structure, so consent should be sought before a law is made for states, but eventually that was not accepted. Now, what impression or what assessment you have of these two basic provisions of the Constitution that constitute the basic legal structure of India's international law policy? Articles 51 and 253 indicate an admirable modesty in respect of international law. Those provisions are inadequate to deal with the problem of opaqueness in the ratification of treaties. This problem India is facing seriously lately. The dissatisfactory role of Parliament in the treaty ratification process remains a matter of controversy. Like this problem, the reluctance of the center, that is the Union government, to enact legislation to give effect to human rights treaties remains unaddressed by Articles 51 and 253. So it is a discretion of Parliament to enact law, to give effect to treaties, and the history of Parliament is that it rarely enacts laws to give effect to treaties. So what you have in the form of a basic legal structure is not translated into practice by the government of India for a variety of reasons. Now, what are the human rights aspirations of India? Owing to its leadership of the developing world, India's expectations from international human rights law include not only the aspiration of the people of India, but also of those people who have suffered under the colonial yoke. Right from the beginning, whenever the question of human rights came at the international level, India did not participate in the debate by focusing on the interests of Indian people. It participated in the debate as if the whole developing world is one family and India happens to be having the responsibility to express the aspirations of the whole developing world. And this is very critical in understanding the larger human rights agenda that India pursued at the international level right from the beginning. Interestingly, internationally, India attaches equal importance to both categories of human rights: economic, social, and cultural, civil, and political. But domestically, the situation is different, because under the Constitution of India, civil and political rights are enforceable, justiciable. On the other hand, economic, social, and cultural rights are not justiciable. They are not enforceable. So what you find at the international level in international legal structures to which India is a party is not the case at the domestic level. India considers group rights more important than individual rights. India does not want international human rights treaty regimes to impose the Western concepts of human rights. India does not want international monitoring bodies in the field of human rights to behave like European institutions. India believes that international human rights institution cannot be built upon the ruins of national sovereignty. In fact, this particular phrase I have borrowed from the debates of the United Nations General Assembly in 1966, when the drafting of the International Covenant on Human Rights was going on. India advocates a step-by-step approach in the acceptance of international monitoring procedures. India is in favor of international action in respect of gross and massive violations of human rights, but not other violations of human rights. India is opposed to linking human rights with environment and trade conditionalities. India's human rights aspirations at the international level are mainly articulated in the form of emphasizing two rights. One, right of self-determination, and another, right to freedom from racial discrimination. India launched its campaign against apartheid even before it became independent. That was one of the first items it had taken up at the United Nations. The issues raised and the position taken by India at international forums, especially the summit meetings of the non-aligned countries, reflect a morally appealing, politically correct position of India in respect of international law and human rights. The preamble to the Constitution of India and Part 3 along with Part 4 state to a large extent India's human rights aspirations at the domestic level. Lately, however, India's human rights aspirations are also expressed in some judicial pronouncements and also in civil society demands. Some Western influence is also visible in India's human rights aspirations at the domestic level. Consequently, the ambit of human rights ambitions of India and its people is very, very large. Still, and it's very important, still, not all human rights enshrined in international human rights treaties acceded to or ratified by India are recognized by India. It's a very interesting phenomenon. You accede to a treaty, but you don't accept all human rights incorporated in that treaty. Like many other states, India has made a large number of reservations and declarations to human rights treaties. Consequently, a number of rights that you find in international treaties to which India is a party are not applicable to India. Although the Indian government has not recognized some of the treaty-based human rights aspirations, the Indian judiciary has recognized some of those aspirations through the process of judicial activism. While a large number of people and civil society actors aspire to seek protection of their rights and freedoms with the help of glamorous, popular international petition procedures, the government of India is not ready to accept such procedures. Now, the question is, when you have so much aspirations, how you will assess whether those aspirations are accomplished or realized? What is the criteria for determining that? And in this regard comes the need of some understanding of those references, those benchmarks that you should apply to understand the extent to which India has been able to achieve its aspirations. And I find at least 10 benchmarks relevant in this regard. First, your aspirations must be accompanied with your intellectual preparedness. There must be some diplomatic initiatives. You must participate in negotiations, drafting of the conventions, and various other legal processes that take place. Then you should have some normative formulations in place to give effect to what you think. You should have a resolution in place, a declaration in place, a treaty in place, or a negotiating agenda in place. And then you must formally accept it. When a treaty is negotiated, and if you don't accept that treaty, then what's the use of your participation in that treaty? So acceptance of the treaty in the form of signing and ratification is another benchmark. Then you must incorporate that law that you have accepted at the international level into your domestic law. Because if you don't do it, then your domestic institution will not be able to take cognizance of what you have already accepted at the international level. And that process of incorporation is very important in the context of India, because India follows the doctrine of incorporation. That means no obligation that is accepted by India at the international level can be enforced at the domestic level until that obligation is translated or incorporated into Indian domestic law. So your the treaty to which you are a party must be incorporated into your domestic law. Then you must institutionalize the process of implementation of that treaty or that body of law that you have accepted at the international level. And then you should be bold enough to subject yourself to international accountability so that others can assess whether you are truly complying with your obligations, international law obligations or human rights obligations. And then there should be a follow-up to what others are saying about you. If an international body says that India is not complying with its obligations, you should have a process, a mechanism in place to give effect to the concerns expressed by the international community. And finally, there should be general support for international law in public, especially among the business communities, education institutions, religious bodies, and political parties, because they are the basic power pillars who influence the decision-making process at the domestic level. If you apply these benchmarks, then you can draw the following conclusions. One finds a mixed bag or mixed account of India's adherence to and reluctance towards international law and human rights treaties. You find both. You find enthusiasm and you find reluctance. And I have found 3 examples to drive home this point. First, India made an outstanding contribution in the drafting of the international covenants on human rights. But when it came to its acceptance, it took more than 10 years for India to ratify those covenants. When it came to Uruguay round of trade negotiations, it was a case of rejection and reluctance. India rejected the idea of launching Uruguay round of trade negotiation. Then it reluctantly participated in it. It was ill prepared for participation. And the result was that now they are beneficiary of the outcome of Uruguay round, but you find a shift from rejection to reluctance to acceptance and adherence. Then you find a third example, nuclear question. India takes pride in claiming that it's a leader of the nuclear disarmament movement. But if one looks into the history of drafting of the NPT, for instance, and preparation for NPT, one wonders what happened. Why did you surrender an opportunity to participate in the process and to influence from inside rather than from outside? In order to realize various aspirations that India has in the field of international law and human rights, India has not utilized all available international legal tools and techniques, opportunities and resources, and shields and swords. And the conclusion you draw on the basis of this experience is that India has used international law more as a shield than as a sword. Now, obviously, when you talk of India as a great power, you would like to compare it with somebody. The question is with whom and on what basis? Given the use of the term superpower, 3 entities obviously come into picture: United States, Russia, and China. On what basis will you compare? I will adopt a legal approach. So I will use 2 references. First, constitutional references, and second, adherence to international treaties. If you look at the Constitution of the United States, you find one of the most impressive articulation written in the original Constitution. And here, I would like to bring to your notice a very important article which is rarely discussed by political scientists and IR theorists, but it has tremendous significance when it comes to compliance of the United States with its international obligation. Every treaty to which the United States is a party is a supreme law of land of the United States. even if that treaty is in conflict with the Constitution of the United States, even then that treaty prevails. And also, international law is part of United States domestic law, enforceable in American courts. So when it comes to United States, its commitment towards human rights treaties and international law, it is of very high quality, and this is part of its basic legal structure. Now, when you come to Russia, you have almost the same situation. When you come to China, then situation is very different. The word international law is conspicuous by its absence in the Chinese constitution. In fact, word international is also conspicuous by its absence in Chinese constitution. But there is a full chapter on human rights and also on minority rights and democracy. Now, what conclusion do you draw after having a look at these three major powers or great powers and India? Both the American and Australian constitutions accord greater importance to treaties than the Indian and Chinese constitutions. Unlike the Indian constitution, the Chinese constitution is silent on international law. While the Indian constitution contains a very good general policy statement in respect of international law, both the American and Russian constitutions provide better specifics in respect of international law. Indeed, India has the most impressive constitutional framework in respect of human rights. The second reference I would like to use to compare these great powers or superpowers, real or potential, is to use empirical evidence with regard to their adherence to human rights treaties. Out of 17 core international human rights treaties, the United States has not ratified 6, including the Convention on the Rights of the Child. Russian Federation has not ratified 3, including the Convention on the Rights of Disabled Persons. China has not ratified 3 treaties and 6 optional protocols, including International Covenant on Economic, Social, and Cultural Rights. India has not ratified equal number of core treaties, including Convention Against Torture. Both China and India have ratified equal number of core human rights treaties. But this equality is fake, and I will tell you how this equality is fake. The number of US ratification of the core human rights treaties is the lowest, and the highest number of ratification is by the Russian Federation. Unlike both China and the United States, India is party to both the international covenants on human rights, and there's a critical difference between India and China and the United States. The United States has attached the highest number of reservations and declarations, and China has attached the lowest number. India is somewhere in between. The United Nations Human Rights Treaty bodies have found many flaws in the human rights record of every one of these 4 states we have compared. Now, what impressions do you draw after going through aspirations, adherence to international treaties, constitutional legal structures, and other aspects of international law and human rights? And I have drawn about 8 or 9 impressions. First, the concept of power has undergone a radical change over the years, is a well-known established opinion. Secondly, international law, including human rights treaties, is less than a hard power, but more than a soft power. Thirdly, no state can claim itself to be powerful by ignoring the rule of law, especially international human rights law. If your wrongs are not subjected to accountability today, don't feel comfortable, because those wrongs may visit you 10 years later, 20 years later, even 50 years later. There's a law in place which states that statutory limitation law does not apply to crimes against humanity, war crimes, and other serious violations of human rights. Fourthly, the power of force cannot survive for too long without the power of dignity, and the classic example is the Soviet Union. Fifthly, the practice of international human rights law demonstrates the power of dignity. So when you talk of human rights, you talk of power of dignity. When you talk of nuclear weapons, you talk power of force. Sixthly, the practice of the core human rights treaties presents India as an enthusiastic leader as well as a reluctant power. Seventhly, the human rights record of India is favorable, comparable to that of the most great powers of the contemporary world. Eighthly, India has not developed and deployed its best resources to utilize various opportunities available in the field of international law and at international forums. And finally, in order to enhance its status in international society, India ought to improve its human rights treaty practice considerably. Thank you, Mr. Chairman.
Mr. Chairman, sir, Australia-India Institute, and particularly Professor Mattu, thank you very much for this opportunity. My getting up to speak at this stage reminds me of what a US president, when called upon to speak extempore, said. If you want me to speak for 30 minutes, I can speak now. If you want me to speak for 10 minutes, give me a week. I've had about 4 hours since the morning. A few speakers have interloped onto my subject. Some others have done something else. The Institute bludgeoned me into producing an 8,000-word paper. Now I have to condense it and do it in 10 minutes. Let me attempt. Well, we had the Nehruvian ghost visit us in the morning, which is not strange. Sometimes the ghost does travel abroad. Though it was a Congress Prime Minister, when I did my paper, essentially when you talk of India and the nuclear regime, you essentially are talking of Indo-US relations, because the rule maker in the second half of the 20th century was US during the Cold War and certainly after the Cold War. So when you determine where India stands vis-a-vis the regime, really you begin with Indo-US relations and you end with that. I've done that in the paper. Now let me first quickly do an overview of India's foreign policy and how I see it, where the regime fits in, how we reacted and where we've ended up. Till 1970, till 1967, we didn't have a major problem with US on the nuclear regime. In fact, the 1953 speech of Eisenhower on the atoms for peace was all very good for India. We got a first reactor from Canada. We even got heavy water from US. Our relationship with Eisenhower was excellent. Prime Minister Nehru's visit there was very good. And Eisenhower in 1956, in fact, issued a national security document saying India needs our help, and he accepted non-alignment. He did not go along with some of the previous secretaries of state of US. He said non-alignment is fine. Democratic India is a necessity in terms of his view of where China and Russia had to be handled. So India's non-alignment was not a problem till much later in the process, which I'll come to. He was followed by Kennedy, and Kennedy was an India lover. As a senator, he had been very pro-India. And therefore, when he came in, and good for US, India ran afoul of China by then, and we had the '62 war. And that's where I must get away from this and say that if all of you who would have heard Jackie Kennedy's whisperings in the last few days, which have come on the television, in one of them, she says Jack told her that had he died after the Cuban crisis, he would have been remembered as a great man. He didn't know he was going to die 2 years later. He still remembered in terms of his unfinished presidency as maybe a much greater president than he might have ended after 2 terms. But Nehru, if he had gone in the 50s, would have been really a great, uncontested great leader of India. Nehru probably the peak was 56. Where we go wrong is when you read Kissinger's book on China, it's not so much we know he has a pro-China slant, but what emerges from the book is when you hear Mao's voice and you have a person who's dealt with all 5 generations of Chinese, it's not the word superpower. I think it should be the word great power. And then you combine it with Fukuyama's latest book, The Roots of Political Order, where he compares India and China. What is the difference? China has been a nation state continuously since 221 BC. India has only fitfully been a state in its current form, twice the Guptas and the Mauryas, and otherwise we've broken up into small units till the British came. Even the Mughals never had the whole of India. They never had the Deccan. They were really ruling the north. And they had a problem. And some say, why did Akbar go into his Deen-e-Ilahi and universal religion? Because the great emperor of India, if he said he was a Sunni, he had to kowtow to the Ottoman court and the caliph there. If he said he was a Shia, then he had to kowtow to the Shia court in Isfahan. So what was he? Ruling the great India with all its riches? He could be neither one nor the other. So it was still, the Mughals were contesting, what is India? How do you spell out India? Because they were only ruling over a part of India. And the crazy Mughal, Aurangzeb, defied this wisdom, tried penetrating the south, exhausted himself, lost a part of his empire to the Iranians, because as he went down, the Shia empire pushed in. And you have the Shah of Iran marching onto Kandahar and writing to the Mughal emperor, the then Mughal emperor in Delhi, and saying, oh, you know, I heard that the shooting and the weather is very good in Kandahar, so I've come here. I think I'll keep it, because they were busy somewhere else. Now, this India had, you know, this comes into independence. This comes into this stage of 150 years of colonial occupation. You don't need Nehru to tell it to be strategically sensitive. This country was going to be strategically sensitive because it's got independence after 150 years. It's always going to compel its leadership to be that way, whether it's Nehru or someone else. But the mistake that Nehru made was that there was his dependence on cronies like Krishna Menon, purblind, fighting with their own chief of staff, not willing to listen to an army chief who resigned because he's not willing to look to the Chinese challenge, and then getting hit on the head. And 2 letters, Government of India sitting on top secret documents, including the Henderson-Brooks report, which they will not make public. One of our journalists has just gone to US and ferreted out 2 letters written by Nehru, frantic to Kennedy, saying, I need air cover, can you send US pilots? Now, you know, why do we cover it up? Nehru was a great man, but he's a great man who ended where anyone advising him, any brigadier advising him would have told him that in November, there's no way the Chinese could sustain the occupation of northeastern India because the passes would shut down in about 4 weeks. Now, whether you went to America or not, they're going to withdraw anyway. But there was such panic. We had Indian Air Force, which was not put in the air. The Chinese had no air cover in '62. But if you see the language used by Mao is very interesting in Kissinger's book, where he says, it's the second time that Mao didn't look at India-China war as a first war. He looked at a 7th century intervention by Chinese troops during the Tang dynasty in the region of Bihar, where they sided with one of the elements. He called it the second time. He was looking at a perspective of about 1,300 years in terms of dealing with India. He said India needed to be punished because they realized that Nehru had managed to project India far beyond its economic and political capability and military capability. They wanted to puncture his balloon and bring him down. So what was required was realism. You needed a realistic reassessment of repositioning India, and India doesn't get repositioned till 1991, and by an accidental prime minister. As US was given its sail into its global dominance, again by an accidental president, Teddy Roosevelt, who was not meant to be a president till McKinley was assassinated. The president was assassinated. He's seen as a rebel rouser who was sent as vice president. He gave the Blue Water Navy, he gave Panama Canal, he gave US before the First World War the wherewithal of what makes it. So it is not a question of values, it's a question of vision. Like they say, it's not 9/11 is not a failure of intelligence, it's a failure of imagination. Nobody thought they could use planes, or some people could. So very often, vision is very important. So we are not values, yes, as Brzezinski says in his book, power and principle. There'll always be an interplay of power and principle in a state. But as somebody again said from the stage, dominantly for a democracy, principles have to be there. But you explain to your country, you explain to the world why you compromise on values and go for power. But India will be a different nation, not a superpower, but a great power. Now coming back to I've gone into others' area because they came into mine, that was retaliation. Now let me go back to the nuclear regime. We had no problem till the wretched NPT starts getting negotiated. Now once NPT comes in, India joins in. Professor here just now asked, we should have been inside the treaty. No, we couldn't be inside the treaty because the treaty as it began to be negotiated, very clearly the 5 is it a coincidence that the 5 permanent members of the Security Council also are the 5 nuclear weapon states? They decided the post-Cold War order, and they put them there, and they kept a special place for them with special rights and privileges. Now, India, with that history, with or without Nehru, with that history, there's no way India was going to join a treaty like that. So here you're defining nationalism, you're defining your past, you're defining your culture. There's no way India could accept it. And that is why India sat out. You sit out, now question is raised, could we have nuclear arms? I've raised that question with some of our physicists. But it's a very peculiar development because the cutoff date was 1st of January 67. If you could have tested by then, we wouldn't be having this debate today. We'll be a nuclear weapon state. Nehru had died. The ghost was still wandering around, but Nehru was gone. Shastri, a pragmatist, had taken over. But he was saddled with a war with Pakistan in 65. And then 2 horrible things happened in the month of January 1966. You can write a book about it and say conspiracy theory. Shastri dies in Tashkent. Within 15 days, the father of India's nuclear program has his plane crash into Mont Blanc in Switzerland. So within 15 days, the father of India's nuclear program and India's prime minister, who's a pragmatist, just signed a peace deal, die. There are whisperings that perhaps Shastri would have given the go-ahead. If we knew the door is closing, why did we keep sitting? Because these 2 guys gone, Mrs. Gandhi came in, new prime minister, she was saddled with a Congress party which thought they will manipulate her, etc. So she had 66 wasted that way. By the time she came in, the treaty becomes applicable in 70. She consolidates power, and by the time she consolidates power, in 74 she tests. Because the treaty is there, she didn't want to be left out. She wanted to say, I have the capability, and I'll blow in the face of this treaty. And that is where there's an assertion of Indian nationalism. It had nothing to do with anything else. And that's where the cleavages, the break comes with the US, because in the meanwhile, Mr. Nixon's come in. Johnson goes away, and Johnson, in fact, Johnson had taken a shine to her. She goes for a visit to US. He came for a drink to the Indian ambassador's house and stayed on. He had a bourbon, had 2, had 3. By then, the guests started arriving, and he wouldn't leave. And the vice president was coming. So then the wife of the ambassador then said, Mr. B.K. Nehru's wife, that ask him, maybe he will stay on for dinner. They asked him, he said, sure. Then they had a problem about putting a chair there. I mean, that was the level of relationship you had. But in came Nixon, the arch realist, the master manipulator, and so on and so forth. He goes to France, builds a writ because he owed one to Charles de Gaulle, starts giving nuclear assistance to them. So there's no such thing as Proliferation Limited and so on and so forth. All these powers, all the P5, at some stage or the other have cooperated with each other. And they have winked at others who have done it. All through the 80s, after the Soviet intervention in Pakistan, 79 to 89, US knew all along that there's proliferation and Pakistan's program is going full speed ahead. Nothing is done. The day they leave Pakistan, 1990, President Bush Sr. says, I cannot certify that Pakistan does not have this program. And everybody knew they had it for 5 years. Now, it is this that upsets India. It is this that got India's this thing, that you have this double standard. How can you do that? And then the noose starts tightening. From 74 to when we test in 98, 24 years we did not weaponize. And the reason we weaponized is because the noose in the 90s is tightened further. 90s was a great time for the proliferation controllers and the custodians of the nuclear regime. You had Saddam Hussein invites America to come and hit him on the head. He walks into Kuwait. He gets sanctions after that. And as a result, his program gets stifled. After that comes in the negotiation of the CTBT. And the pressure builds up on India to sign it. Now, India would have been willing to go along with that, but the discriminatory nature of that is what kept India away. These 2-3 things that came along, and the extension of the NPT in perpetuity in 95 is something that really upset India, because now what was seen as something reviewable was made permanent in 1995. Though there'll be review conferences, but it was for all times to come. So now you hardened it in concrete. You said those who are outside will remain outside, those who are inside are inside. Now here is India now further isolated, further pushed into the corner, and this is an India which was going, which had got Narasimha Rao had opened the economy. He threatened to test at one stage. He came under pressure because the economy still hadn't clicked fully. And then he goes away, and you have 2 years of coalitions in India, and then comes in the BJP-led government, which in its manifesto said, we will test. And when everybody was surprised later, they said, but parties are not supposed to do what they say in the election manifesto. They said, no, but they had put it right there. You didn't need CIA to tell you that. It was right there in their manifesto, and they did it. No, therefore, that finally, what it did was that Indo-US relations were actually, that ghost was always there in the corner. Clinton was trying to improve relations with India. They had added various subjects. They had set the next steps. Okay, they had set the next steps in a strategic partnership and so on and so forth. But this particular element, there was the trinity of issues: defense, space, civil nuclear. Civil nuclear, you said, no. If we touch that, a global regime will collapse. Something horrible will happen to the world. So that we don't touch, but we start improving. How do you improve relations between countries? How do you become close to each other if you leave a large branch of technologies? And in fact, this is precisely what it was. After the deal, President Bush came to Delhi on a private visit. He was invited by one of her newspaper owners for one of their summits. And I remember sitting there, the first thing he said, in his own Texan direct way, he says the deal was not about nuclear energy. The deal was your passport to the world. I think in his own way, he put his finger on it. It was essentially about lifting the high technology restraints put on India in the guise of keeping India from proliferating or from going the nuclear way. And it is that high technology restraint which was functioning as a great restriction on India at a time that China had broken out, and the Chinese had managed to do this. The two things which are coming from the US intervention, US countering of the Soviet Union and Afghanistan. Two things which they thought the Cold War has ended. As somebody quoted earlier, Fukuyama said, end of history and so on and so forth. But actually the seeds of what is contesting US and their allies today was sown in the very victory which was achieved in 1889. One was radical Islam, and the second was China. Because China got 10 years straight away under Deng Xiaoping, rising from about 81, getting technologies from the West, building up their capabilities, and by the time the 90s come in, they're all there. And by 2000, they're even more there, and now we say, they are there. That's what everybody said this morning. Anyway, so where does it leave? And that's why Bush's deal, maybe it wouldn't have happened. Can you imagine Al Gore winning that election because of some silly chads in Miami? If that had happened, Mr. Shamsaran sitting here would have been busier because we would have been quarreling over climate change rather than the nuclear deal with India. Now Bush comes in, 2001 comes in, all eggs are broken, new omelets being cooked. That's where I think finally Indo-US relations are put on track. And Australia was taken by surprise because as a spokesman of the ministry when we tested, they probably gave it to me that time as the first Sikh to be made the spokesman because bricks were flying, I had headgear. So, yeah. So I was wondering why they put me there. But anyway, I was there. And the interesting thing is this one staff officer, defense staff officer, Australia said, fix India. And the way of fixing India was pulling out one defense service officer being trained here in the middle of his class, pull him out and put him on a plane. So that was great Australian retaliation for India having tested. But India got very angry. They said, we don't want to buy any coal from you and have anything to do with you. And then Australia was taken by surprise because Clinton, Brownback, Senator Brownback wanted to sell wheat to India. So we got wheat exemption, Brownback 1. It became Brownback 2, which Clinton signed. And it was back to business as usual between our foreign minister and Stoke Talbot. But Australia was left out. They said, hey, we picked a quarrel with these guys. You are made up with them. What is going on? So, but this only shows that India was right. I say, oh, we'll sort out our relations with Australia separately. Let's talk to the big boy. And I think the big boy, we began talking. And finally, with Bush, it got fixed. Now, where does that leave us vis-a-vis the regime? There are three elements to, very quickly, to nuclear energy. One is growth, environment, what he'll talk about. And the other one is non-proliferation. And you cannot do that without nuclear energy, though there is revisionist views on that post-Fukushima, in India also. one of the persons in the morning said, but India passed that horrible act. But why shouldn't India pass that act? When US was complaining that why are you passing your liability law, was the very time that they were punishing BP for the oil spill in the Bay. Now, there's a different set of rules when you have their fish resources in the Gulf being affected. And here, a Bhopal gas tragedy judgment, which had been in a court for a long time, was reopened by a court as this bill was being debated in the parliament. And once that came up, that Union Carbide was let off, and you reopen that case, public opinion got agitated. As public opinion in Australia, when the Labour government came in, got or did not get agitated, but we are told got agitated, so we can't be sold uranium. So public opinion, once it gets agitated, the governments have to do what the public opinion says, or at least they say the public opinion says. So in this case, we had to then tighten the law, and the law is uniform. It's applicable to all countries. If the Russians are willing to come and do business, or the French, now US, what it does is, it goes behind the back to the NSG and gets the ENR technology restricted only to be given to countries that sign the NPT. Now, this is not in good faith, because we were told that it'll be a clean exemption. We were told that we will get full access, and this is not full access. This is just 1 minute. The restriction of that access. Now, whether you bring India into the tent, India can't be half in and half out, and that is where I think President Obama did a flip-flop in 2009, but by 2010, he got back on track. So when he came to India in November 2010, he did two things. And by then there was a track 2 in which I was a part, and et cetera, which had also been talking to the Americans, that you cannot amend the NPT. You are scared of the bargain which will break up Article 4, Article 6, and we cannot join it in either, you will not take us as a nuclear weapon state, and we cannot join as a non-nuclear weapon state. So let's work past it. And working past it is the larger regime consisting of one named after your country, the Australia Group, the Wassenaar, the MTCR, and the NSG. So if India becomes a member of the superstructure which is being built around it, in addition to other safety and security elements, the summit, in fact, last night, President Obama, talking to the UN, talked of the Seoul summit, the second meeting of the security summit, that there is a combined interest. India straddles the sea lanes. We have seen that. India has capabilities in the Indian Ocean. We have not joined the Proliferation Security Initiative, but we have taken action against DPRK vessels going through. India is a vital element to non-proliferation, to technologies which may be proliferation resistant, like the use of thorium cycle, which we are now just stabilizing. Therefore, India is a net gain. And net gain in terms of non-proliferation, net gain in terms of a player which comes as a part of the thing in an Asian security structure which is emerging, where we don't say that we either contain China or engage China, but certainly we must build alliances around China to ensure it does not regress to its Middle Kingdom syndrome of being center of the world. But I must finish by telling you that in the Tang dynasty, there's a sinologist sitting here, Mr. Shamsaran. I'm an Arabist, but when there was a debate going on, an Indian Lama tells the Chinese that you say you are the Middle Kingdom, then why didn't Gautam Buddha choose to be born here? Why was he born in India? So that is a soft part of India. Thank you.
So we've had two fabulous erudite and eloquent presentations, one perhaps normativist and one realist, but both engaging with critical questions about India's relation to international regimes. Our time has officially expired, but I'll take questions until Elise tells me to stop. So please, do we have some questions?
Hi.
Bhatia.
Ravi Bhatia. I was living in the United States in the 80s and early 90s. And I've seen firsthand open smuggling of nuclear material, instrumentation, metals, and systems from the United States to Pakistan, and two entities were involved. The First American Bank and another company called BCCI, right? Bank of Credit, Commerce, and Industry, both owned by the Dubai royal family. And that was open secret in the United States, and no one said a word.
No, I
agree. And you will see now after US leaves, yeah, there are the Khoshab 3 and 4, which are for producing plutonium, are being rapidly put in stream in Pakistan to be on stream by 2012. Why 2012? Because then US starts withdrawing. When they don't need to be in Afghanistan or Pakistan, that's when the sanctions may come. But in the meanwhile, they've lined up Saudi Arabia and UAE. Because with the Iranians going there, they'll have new people to provide to and new people to provide them. That thing. So this is a very old linkage. Monies come from Saudi Arabia, UAE, is generally well known, and they're part of the same larger group.
So, question down here. Oh, did you want to come in?
Yeah.
Sorry.
This is a statement of facts when you say that this is happening. The question is, what cost should be attached to this kind of behavior, which is violation of not only domestic law, but also of international law? And that should be the main concern of those who are willing to confront the proliferation problem. And the difficulty that once you neglect that aspect, you are underestimating your capacity to create remedies. Honestly, international law offers those remedies. The problem is that realists, not of his kind, but other kind, they don't explore those remedies. How can violation of law cannot be questioned? This thesis is not possible. You can use different tools and techniques under international law and also domestic law to answer what concern you have rightly shared with this audience. And that should be the creative thinking on the part of both lawyers and policy makers to explore legal options, and that is what lawfare is all about. Don't just rely on power structure to confront those kind of problems. Use tools and techniques that are available under both domestic law and international law.
Ramesh Thakur from the ANU. Ambassador Singh, just to add to what you were saying, a comment rather than a question. Sometime during the 2000s, I happened to be in the same advisory committee to the Secretary General Annan as Strobe Talbot. And we spent a whole day together, and for alphabetical reasons, I ended up sitting next to him. And by the end of the day, he conceded that it's because of the tests in '98 that the United States engaged in the highest level of sustained strategic dialogue with India ever since independent India, and as a result, had a much better understanding of India's strategic imperatives and concerns for the first time in the bilateral relationship. So it's another example of an unintended outcome of something that had entirely different motivations.
Thank you very much. I'll just quote Stephen Cohen's one-liner. He says, India is a friend which won't be an ally. Pakistan's an ally which can't be a friend.
At the back there, please.
Julian Leeson from the Menzies Research Centre. My question's for Ambassador Singh. How's Australia's decision to cease uranium sales to India affected relationships between Australia and India, do you think? And where has India sought to get uranium from now that Australia has moved out of that space?
Frankly, with the trade being open to India now, it's not really, like oil. You say, you know, what will happen if Iran doesn't give? There's a global market. Prime Minister has been to Kazakhstan. We haven't gone to Niger and so on and so forth. But once you're in the market, frankly, we've run a bit late. Otherwise, in terms of a three-stage program, we really should be going into thorium, of which we have the second largest in the world. And that is, there you're burning plutonium. So at the moment, it's not a problem, but it becomes a problem in terms of seeing, do you really trust me? It's a question of, somebody said, I'm sorry, I can't have a drink with you. My wife doesn't like you. Now, what kind of friendship do you have with a guy? You know, either you are friendly enough, say, oh, we'll have a blast. Or you say, no, I'm sorry. You know, she doesn't like you, I like you, you're a nice guy. So you'll have a structured relationship. So it is more for that, for signaling that you're an okay guy.
In one sentence, this Australian policy has adversely affected its relationship with India. I can share something more precise with you when we are in private, because
We've got,
Over a drink, this.
we can have a blast. Question here in the middle.
My question is to Ambassador Singh. Thank you for that wonderful historical perspective. My question is, looking forward into the future in a post-Fukushima world, what benefit do you practically see India actually being able to get from the nuclear access to nuclear technology? Do you actually practically see it being used?
Prime Minister's insisting. There's been a resistance in 2-3 places. People have started. In Kundakalam, people are agitated. On the other side, the French side, people are agitating. That's different. Delhi's then rushed a regulatory board, an independent regulatory board, to certify. And then in the meanwhile, you have an accident in France itself, where they said, no, there's no emission. Germany rolls back and say we don't need it. But how do you do it? Because with our energy demand, and we need, by 2050, I think Prime Minister has been saying a quarter of our energy need would come from here. If it doesn't, then you're caught between the devil and the deep sea, which is emissions, which you need to control, and the energy need for an economy growing at 8 to 9%. So how do you balance the two? I think this will be talked about by Mr. Shamsaran later. But essentially, you're caught between that. But government will find it a little difficult, because after Anna Hazare and so on and so forth, there's people power. They start agitating and saying, no, we don't want it in our place. So they'll have to be assurance. Even the Japanese, the new Prime Minister said, I want to reopen. But they're also reopening plants after consulting local communities. So I think it's a new ball game.
If the question is confined to nuclear energy, then what he said is excellent. I mean, I subscribe to the same view. But if the question is addressed in a larger context, that is trying to link it with the deal and deal's larger objectives. So it is possible the deal may not deliver to India what energy dimension might have been thought of, but there are many other dimensions that are accomplished to a great extent.
And a final question over here on my left, down the front.
Thank you. My name is Dr. Manjula O'Connor. Question is on human rights. The Constitution of India has beautiful human rights written into it, but you go to India and the civil and the social rights are so appallingly poor. I mean, what can the intelligentsia of India do to give the people right for roads, for clean neighborhoods, for cleaning garbage, for sanitation, for living in with decent dignity and respect? That is human rights.
Yeah, you're absolutely right. They are human rights, and they are recognized as human rights under the International Covenant on Economic, Social and Cultural Rights. The difficulty is that the regimes that you have in place at the international level and also what you have at the domestic level allows a discretion to the government, to the state, to decide about the speed, direction and priorities in respect of human rights. And this flexibility has been used or abused by the states to downplay the importance of the rights that you are mentioning. And the result is that you have a large number of civil society movements within India that are trying to impress upon the state that these rights are very important. And in addition to that, the judiciary in particular has been very, very strong. In fact, one of the most fundamental decisions ever delivered by the Supreme Court of India was in a case called Ratlam Municipality case, and it dealt with the question what you have just said, and the history of public interest litigation in which people participate in enforcement of human rights through judicial process is started with the concerns that you have shared. So there is a momentum. It has not come in the same way as you expect and I expect, but there is increasing assertion on the part of civil society and increasing sensitivity on the part of judiciary and reluctant willingness on the part of the state to do something.
Well, friends, colleagues, our time has come to an end. I'm sure you'll agree with me, I hope you will, that this has been a fascinating and stimulating session ranging over a huge variety of topics. Please join with me in thanking Ambassador Casey Singh and Professor Yogesh Tyagi. Thank you.